Hello, this is Kanu. What if the Congress wants to make a law but has no legitimacy? In the past, they spammed the Commerce Clause, a beautiful clause that empowers the Congress to regulate interstate commerce. But in my opinion, some of the use of it was really absurd. Today, I brought two Commerce Clause related cases, Heart of Atlanta Motel v. United States and Lopez v. United States. Apparently, the Congress used the Commerce Clause appropriately for the first case, but not for the second one. But in my opinion, they're both nonsense. Heart of Atlanta Motel v. United States took place when the Civil Rights Act of 1964 was passed, that bans racial discrimination in public accommodations as long as they affect interstate commerce. But the owner of the Atlanta motel wanted to keep refused black customers, so he sued the federal government, saying that Congress can't force us to do it, and is it okay to use the Commerce Clause for making an anti-discrimination law? He also asserted that his business was local, not on interstate, so his motel is immune to the Civil Rights Act of 1964. But the Supreme Court said, no sir, your motel is adjacent with Interstate 75 and 85, and 3/4 of your customers, literally 75% of your customers, are from other states. And sir, you did nationwide advertisements too. Think about it. If you refuse black customers, black people from other states won't be able to visit Atlanta since there are no place to sleep, and that will eventually influence the state-by-state economy too. So you can use the Commerce Clause for sure. The Congress had no choice. They couldn't use the 14th Amendment's Equal Protection Clause, which is considered better because of 1883's Supreme Court decision that says the 14th Amendment was for the states, but not for individuals' business. Okay, but wait a second. Why did they use the Commerce Clause for anti-discrimination law, a moral-related law, but not an economical law? Why is it used so widely? The Commerce Clause is actually divided before and after Franklin D. Roosevelt. In the 1700s and 1800s, the Commerce Clause was really about wagons, railroads, trains, something like that-ish, but Franklin D. Roosevelt did the New Deal, a nationwide economical pivot that contained lots of government-funded projects and programs for reconstruction. And some people were concerned about that the Congress had a legal power to interfere to the economy like that much. So from then, Franklin D. Roosevelt said, a part is a part of a whole, so it is inevitable to influence state-by-state economies too. Okay, but what if it goes way too far? In the case Lopez v. United States, the Congress used the Commercial Clause to ban the possession of guns near schools, saying that if you allow guns near schools, students will be afraid of guns, so they won't go to school. And if they don't go to school, that will lead to poor education, and students with poor education won't be able to make lots of money when they grow up as an adult. And that will eventually influence the state's economy. And if you allow guns in your schools, that means more gun violence. More guns simply just means more gun violence. So the state needs to pay off for the gun incidents that happen because of more guns in your schools, and that will eventually increase the insurance price of the entire states, and that influence the state's economy. Oh, this is literally nonsense. It seems like really nonsense. The Lopez v. United States is a case that went way too far, but I think this is not the only one that is absurd and nonsense. In my opinion, all non-economic Commerce Clause laws are just seems like adding up reasons to make legitimacy without providing proper logic. So I hope for sanity to Commerce Clause. Thank you for listening so far.